Thank you, Chairman. It's a great privilege to be here this afternoon. I'm a former student of the university here, and I'd like to compliment Owen and Anya on the wonderful job they have done in organising this event. It's very much a flagship event now for members of the environmental movement and indeed members of the legal profession in Ireland that are concerned with environmental issues. I'm going to speak about an issue which I have a deep and passionate interest in, which is the marine environment. And on your slide there's three photographs, and it's to provide a little bit of context for you. The first one is on the left of the slide is the sinking of the Prestige vessel, and we heard from Margaret this morning about some of the subsequent case law in the European Court of Justice. My point is, when we get it wrong in the marine environment, it can be catastrophic for communities and indeed coastal communities here in Ireland. The second slide is of Lophelia, and for us laypersons, that's Deepwater Coral. It's a photograph taken about 70 miles to the west of my office in Galway. And Lophelia represents, shall we say, the underwater environment that we can't see, very much a pristine environment. And obviously the third photograph is perhaps the one which we're kind of familiar with, which is the coastal environment, and obviously issues such as water quality are of importance to all of us. Now, in my presentation, I'm going to address three issues. I'm going to provide you with some background to the enforcement of EC law in the marine environment, and I've more or less divided the enforcement element up into two component parts. First of all, the component part dealing with the marine environment in a general sense, and the second one, which is a very topical one, one which there is great controversy, and that is the enforcement of fishery law. And thirdly, I'm going to explain at the end of my presentation the reform. We're living in pretty dramatic times in relation to what's going on in the marine environment, and I hope to be able to highlight for you some of the major regulatory instruments that are going to come down the tracks over the, shall we say, over the short term in the next 2 to 3 years. Obviously, the European Union is a landmass. We can see it there, but obviously there are also some very important enclosed and semi-enclosed seas. These are legal terms which we have in law of the sea. Example of an enclosed sea is the Black Sea, a semi-enclosed sea, the Mediterranean Sea, important regional seas such as the North Sea, and obviously international straits such as the English Channel. Two other statistics which I'd like to mention here is the nature of the European coastline, which is very long. It's over 100,000 kilometres in length. And the last figure up there on the slide is the geographical footprint of sea areas under the jurisdiction of the member states, and that's 4 million square kilometres, much larger than the European landmass. To demonstrate that is, when you think about the marine environment, essentially you have to think from the Black Sea out across the Mediterranean Sea, up the Atlantic coast, into the Baltic Sea, and indeed up into the Arctic Ocean. One issue here is, I suppose, a very important issue for lawyers is we don't really define the marine environment in legal instruments, and indeed we have a number of rulings and judgments from the European Court of Justice which says effectively the marine environment is where member states exercise legal competence under public international law, and effectively that means that the geographical scope is quite different from what we here have on land territory. So, for instance, if we take the slide, it's the jurisdictional model that we use to explain jurisdictional issues in the marine environment, and obviously we're familiar with land territory. Most of the instruments that we have heard about today apply to land territory, but obviously the state's jurisdiction extends out to the limits of the territorial sea, and that extends to a distance of 12 miles from the baseline. Beyond that, our jurisdiction is quite limited. We have sovereign rights in an area which we refer to as the exclusive economic zone, and we have sovereign rights in relation to the continental shelf. And I suppose the continental shelf is where we get the mineral resources. The exclusive economic zone is where we get the fishery resources. Seaward to that, we have areas beyond national jurisdiction. However, if a vessel which is flagged in Ireland sails out into the high seas, it's still subject to the jurisdiction of the state. Jurisdiction follows the flag. Now, this is a kind of a slide which gives you an idea of our footprint at a European level when you map our kind of jurisdictional model onto a spatial map. And you can see, right, in actual fact, Ireland is one of the larger member states. You can compare it there to Germany or indeed France. You will see, right, that in terms of the marine environment, we have considerable responsibilities at a European level, and I'd like to come back to that issue later in the presentation. Now, moving on to the European legal order, obviously we heard a number of presentations today about the very complex legal instruments, and I suppose we heard also from the Minister that the law flows downwards, and most of our discussions today have concerned European legal instruments as opposed to national legal instruments, and I'd like to come back to that issue. A second point which the Minister raised was the international component, and certainly in the context of the law of the sea, we have a very definitive and complex international agreement, the 1982 Law of the Sea Convention, and the European Community is party to that convention, as indeed is Ireland. My last point in relation to the legal order is generally we regulate by means of sector policies. So we have individual policies for transport, energy, fisheries. Indeed, we have about 32 common policies which apply to the marine environment. Now, just to take you through maybe one or two slides on the history of marine environmental measures, and the first point is, right, there is no history prior to the 1990s. No major legal instruments which apply on a global scale to the marine environment. However, we saw in 1990 a political commitment at a very high level in the negotiations leading up to the Maastricht Treaty, and in the declaration by the heads of states, right, they said, right, that the environment, or the right to a clean environment, also included the right to a clean marine environment. Many of the measures that we have are more or less projected in relation to the coastal zone, and I list there one, for example, which is the Bathing Water Directive, and which is of great importance. Now, what are the consequences of that? And if we go back to, say, very important proceedings which Ireland launched against our sister member state, the United Kingdom, in the Mox Plant case, the reason why Ireland took that litigation outside the dispute settlement procedures that we have within the European Union was that Ireland felt at the particular time that there was no applicable EC measure. Effectively, what happened was, in the course of, shall we say, maybe 30 years, is the big substantive bodies of law were built up by international organisations such as the IMO in London, which regulates shipping, and indeed in relation to the marine environment, we have the 1992 OSPAR Convention. Now, the law went on in practice in a strange kind of a way, in the sense that it was driven forward by events, and we had events such as the Brer, which was the sinking of a tanker in the Shetlands in 1993, the sinking of another tanker in France, the coast of Brittany in 1999, the Eureka, and indeed the one which is shown in this very dramatic photograph, which is the Prestige in 2002. And in response to this, it became clearly evident that we needed a political commitment at a European level in relation to the protection of the marine environment, and that's very much evident in the 6th Environmental Action Programme, which has a thematic strategy for the marine environment, and that was set out in 2002. Much more important in terms of what's happening at the political level is we had a very fine College of Commissioners appointed in 2005, and within their portfolio they made the political decision to adopt an all-embracing maritime policy as their programme for government at a European level. And Within that programme, they appointed a commissioner, Commissioner Borg. You see him there in the centre photograph, a Maltese commissioner, a very capable and competent lawyer, with specific responsibilities for fisheries and maritime affairs. And then if you move across the slide, he and the President of the College of Commissioners, Commissioner Barroso, brought forward an agreed paper in 2007. Now, following on from the Green Paper, there was the adoption of a very important document which we refer to as the Blue Book. And essentially what it said was there was obligations on Member States to adopt integrated maritime policies. Now, I'm going to come back to that with specific reference to the Minister's intervention this morning. The second element was that there should be guidelines for national policies, and this is of huge relevance to Ireland. The third element in the Blue Book was there should be a roadmap produced for marine spatial planning, both at a European level and indeed at a national level. And of course, a very important consideration is there should be appropriate stakeholder consultation. Now, why did the community propose integration? And essentially the facts speak for themselves, and these are facts taken out of the Blue Book. 16% of the European population lives on the coast. 85% of the coast is developed. We have climate change, and I'm afraid the figures are a lot more dramatic than what I present on the slide there, which is the European mean, 3 millimetres per annum. At an international trade level, 90% of European trade goes by sea. 40% of the world's fleet is owned by European ship owners, and we have a lot of new activities in the marine environment, and I've listed some up there, obviously wind and ocean energy, aquaculture, and obviously new resources such as gas hydrates. Now, what has been the progress in the implementation of the policy? And I need to get through one or two slides before I get on to the key enforcement issues. The first thing is we've had institutional change within the College of Commissioners. We have had institutional change within the organisation of the European Commission. In particular, they've set up a specific Director General with responsibility for fish and maritime affairs. We have a very important instrument, the Marine Strategy Framework Directive 2008, which sets out very specific targets which have to be achieved by 2021. You will see on this map here on the right of the slide is the footprint of the predictor instrument, the directive, the Marine Strategy Framework Directive. And I suppose what's a very important issue is that the policy has been driven along with a view to implementing existing obligations, particularly those obligations set out in the Regional Seas Conventions and existing legal instruments. It's a regional approach, so this is good news for Ireland in many respects, insofar as there are specific policies for the Arctic, and that's indicated there by the polar bear jumping from one iceberg to another. We also see something which the Minister mentioned this morning, which is very prevalent now in the legal instruments, which is these new tools and approaches. One which is quite important is the ecosystems approach, and the second one is the precautionary principle. Thirdly, the normative framework hasn't really changed. It still remains the international legal framework as set out in the Law of the Sea Convention. And the fourth element, which is the key element, is that it depends on Member State action, and it's very much critical that Member States get their act together in relation to enforcement and compliance. Now, I'm going to move along in relation to, that's the marine environmental policy in a nutshell. I'm going to move along to an element of European law where we have considerable experience in relation to enforcement and compliance, and this relates to the common fishery policy. A policy which was essentially set up in 1970 before Ireland acceded to the European Community. It's a policy which allows equal access for Member States' vessels to each other's jurisdictions. It's a policy where nobody in Ireland really appreciated the implications of that until 1976, when our jurisdiction extended out to 200 miles. And it's a policy which effectively, the rules weren't really agreed until 1983. It's a policy where we've had major reform in 2003, and it's a policy where we've had policy failure because we've had very poor enforcement, and that has become very much evident over the past 12 months. Now, in relation to fisheries and the environment, there are kind of three key issues. The first of all is obviously fisheries has to be sustainable, and 82% of European fish stocks are overexploited. We still have a big issue with non-target species, marine mammals, bycatch of birds, seabirds, and thirdly, we are now seeing the application of the Habitats Directive in the marine environment, and we've had some important jurisprudence in relation to that in the European Court of Justice. In relation to fisheries and the European maritime policy, if we go back to the Green Paper, one of the things it says is that the fishery sector bears an unfair responsibility in relation to the improvement of the marine environment, and it poses the question which it answers, and it says this is the industry which is easy to identify and to regulate. And I think it's important because we've learned quite a lot about the enforcement of community fisheries law. Essentially, it's a member state's competence. So here in Ireland, we're compelled and obliged to enforce the law. The European Commission has a very limited role in relation to oversight. We have a European agency with effectively no powers, and we've seen a number of important proceedings, and Brian is going to mention some of these proceedings in the European Court of Justice, where member states have been taken to task for failure to uphold their community obligations under Article 226 of the treaty, and indeed we've had one very dramatic case against France, where the court held that France had failed to implement a judgment of the court, a set of proceedings which went on for, believe it or not, 21 years. Now, all this is very interesting until the European Court of Auditors did an audit on the policy, and it looked at 6 member states, and if you have 10 minutes and you want to know anything about the enforcement of environmental law or fisheries law, this is 10 minutes you won't waste in reading this report, because essentially it sets out a very concise list of failures, and I've cited just 2 here. For example, a state which I've always regarded as the model of best practice, the United Kingdom, and in their audit it revealed, for instance, that 90% of infringements of the law detected in the United Kingdom didn't end up with prosecutions, and I will take a question on that afterwards because the answer is very interesting. Quite controversially, it found that the European institutions had failed with their obligations, and particularly in relation to taking enforcement proceedings against the member states under Articles 226 and indeed Article 228. More to the point, it found that the community continued to spend in member states where there was major non-compliance with the law. Now, as a result of that particular audit, the European Commission last year looked at the possibilities for law reform, and they said essentially there was 4 possibilities. The first one being no change. The second possibility was to amend the existing regulation and to introduce a code of conduct. The third option was to adopt a new regulation in relation to enforcement. And the fourth option was to centralise enforcement at a European level. And that's, I suppose, the nuclear option. Now, the result was they went for option 3, and we have a new draft regulation on the table. It's been discussed as we speak, believe it or not, today. And it has widened out the scope of the fishery enforcement regime. It's no longer seen as an issue which goes on at sea, but it imposes kind of a wide range of obligations throughout the whole process, from fishing through the marketing of fishery products and even to us, the consumers. The second feature in the draft regulation is it puts a huge emphasis on new technologies, particularly satellite monitoring technologies, electronic logbooks, and obviously an issue which was debated in the Oireachtas over the last 2 weeks, quite controversially. It said that the inspection resources within the member states should be shared, and this is something we have to think in relation to the wider issues in relation to our jurisdiction and other areas of the law. In relation to the key issue of sanctions, it says the minimum level of sanctions has to be specified for serious offences at a European level. So essentially what's being set out in the regulation is a threshold, and that's what's going to be applied at a European Union level. A very good idea is this notion of a penalty point systems for vessel owners and indeed for the masters of vessels, and indeed it introduces this notion that financial aid can be withdrawn from member states who failed to implement their community obligations. Draft regulation in European institutions, no enhanced role for the European agency, surprisingly enough, falls well short of what we would expect in relation to independent inspection powers, and essentially what's envisaged there is this continuation of a NODIS system at a European level. Now, the schedule, and that's Commissioner Barroso there, I suppose a wonderful president for the College of the Commissioners, introduced the proposal last November. It had its second reading on Tuesday evening. Certainly within the Swedish presidency towards the end of the year, the latter half of this year, we expect that this regulation will be through the process and it will be into force on the 1st of January of next year. Now, in relation to conclusions, what can we say about the legal landscape? Well, it's very dynamic, it's changing, and I think we're going to have to reflect very much at a national level about how we're going to take on our new responsibilities. The second element, which relates to an intervention made by the Minister this morning, is right. The new approach is very much based on new tools and principles, and I've just listed two here. Obviously, the ecosystems approach is alien to most law of the sea lawyers, and I'd be interested to hear your views perhaps in the questions and answers, right, in terms of the practical application of this approach to the big issues that we need to address. One which is more familiar, obviously, is the precautionary principle, and that is very much to be welcomed. The third element is the enforcement and compliance is very much at the top of the political agenda, and this leads me to an issue which I suppose is very important at a national level, which relates to it's all predicated on member state action, and that's where we're inherently weak within this jurisdiction. And I'll cite by way of example, right, is we had very much a coordinated approach at a national level with the Department of the Marine. And we no longer have that. And for instance, this morning we heard from the Minister in relation to, the one reference to the Marine was in relation to the foreshore, where the same government department now is going to be responsible for promoting offshore renewable energy, as well as licensing of offshore activities under the Foreshore Acts. And obviously, prima facie, there seems to be a conflict of interest there. The third element I'd like to mention is, right, the marine environment is obviously of great concern to us all. It's a very difficult environment to work for, and indeed Owen comes from a very fine fishing family up there in Donegal. Should I mention that or not? But in any case, I would like to mention to you that it is a difficult environment for people who operate out there, and I think we've seen very tragic consequences of the environment that people work in, certainly in Connemara this week. I have a paper, I will circulate it, and I have a publication out on this, Marine Resource Law. If you have any questions here, I work in the university, so pick up the phone, send me an email. I have lots of time, and in relation to the marine environment, I think it's a collective responsibility, and again I'd like to thank Owen and pass over to Brian. I'm available for questions until 7:30 this evening.
Thank you very much, Ronán.